Hi friends, this is Krish, the Urban Naxal, and we are talking once again about the allotment letter pro forma of Runwal My City Phase 1 Part 1. This pro forma allotment letter has been downloaded from RERA and it is available along with the agreement pro forma. Now this allotment letter pro forma has 24 clauses. In our first installment, we discussed only the first 3 and 5 clauses. After that, today we are going to discuss another 3 clauses which are absolutely relevant for payment. These are the clauses that govern payment from you. See friends, you have to understand that this allotment letter is not really an allotment letter, first and foremost. They are not even calling it provisional allotment letter. It's not even a provisional allotment. It is a conditional allotment. It is conditional on so many things which are written in the allotment letter. And it is an allotment which can be cancelled at any point of time if you have a disagreement with the builder. You don't have to be wrong. You don't have to do anything wrong. You have to merely disagree with the builder. You have a disagreement and your allotment will be cancelled. This is what the builder is saying. This is what Runwal is saying. And he is setting up a ground where he is saying, listen, all the rules are mine. What I say is the law. What I say is the only truth. Whatever you say doesn't count. What you say, what you think doesn't matter. There is no rule of law. What we have here is jungle law. Might is right. What I am saying is right. You have already given me some money. You have given me several lakh rupees of money. Before I have issued you this letter which is called allotment letter. But let us be clear. We are not allotting this to you. The flat that you have chosen, we have not allotted. We are agreeable to allot if you are going to accept all these conditions and then you are going to scrupulously observe each and every condition and if you don't disagree with us. If you have a disagreement with us, we will cancel this allotment and we will forfeit your entire amount. This is what they are saying. Now, so they have prepared all kinds of grounds based on which they can cancel your allotment. And there are very few things, you have to be like a railway train on a track, absolutely straight and narrow. Thoda idhar, thoda udhar, your allotment is cancelled and they will forfeit whatever you have given them. That is what they are saying. It's unlawful. Yes, it is unlawful. But are you going to go to court against them? Because that is what it will take for you to enforce the law. Now, let me read you some of these provisions. They are absolutely horrible provisions. Payment schedule. They said all your allotment is subject to payment schedule. Now, your allotment is not subject to the money you have given them earlier, which may be 4 lakhs, 5 lakhs, 7 lakhs, something like that, for a flat of around 50 lakhs. What they are saying is payment schedule is as below. Now look at this, just understand whether it is fair to you or not. So they are saying 9% or more before issuing this letter. So let us say around 5 lakhs before issuing this letter. 20% on intimation of commencement of plinth work. Now, please remember, words matter. The way they say things matters. These words are not there because someone was careless. These words are there because a lawyer was extremely careful with each and every word, each and every comma, each and every full stop. So what are they saying? 20% on intimation of commencement of plinth work. Does it mean plinth work? Is it the same as 20% on commencement of plinth work? No. They will intimate you that plinth work has commenced. Does it mean that plinth work has actually commenced? No. And they are making it very clear later on in the same allotment letter. They will intimate you that plinth work has commenced and you will have to pay them 20%. This is what they are saying. After that they are saying 50% on intimation on commencement of slabs divided into total number of slabs. So let us say there are 25 slabs. Okay, then they are going to take 2% per slab. 2% per payment, per installment. Okay, every 2% they are saying demand will be sent for 2 slabs together on commencement of the first slab. Now they are going to tell you that 4th floor slab has commenced, which means 4th and 5th they are going to build using your money, assuming that. Does it mean that 4th floor has commenced? No. Does it mean it is commencing the same month? No. Does it mean it is commencing after 6 months? It's possible. Does it mean you can hold them accountable and you can say, please give me proof of commencement? They're making it very clear. No, you cannot ask us for proof. We have sent you intimation, that is the proof. That's it. So what else are they saying? They're saying 50% on intimation of commencement of slabs. So earlier you already paid them 29%. Okay? Little more than 1/4, little less than 1/3. 50% on commencement of slabs. Now when the slab work is complete, you will have paid them 79%. After that, 4% on intimation of commencement of brickwork, 4% on intimation of commencement of internal plaster, and so on. Only 3% remaining for possession. Okay? 3% on possession. So 3% is what they are going to charge you with the possession letter. Before possession, they can take 97%. Does it mean that 97% of the work is actually complete? No. No. It only means that they have intimated you that 97% work is beginning. Commencement. Commencement, not completion. Number 7, here is what they are saying. Again, understand it clearly. In case you propose to commence furnishing the said flat prior to possession being offered to you, then we may grant you such permission subject to your payment of entire sale price, interest if any, taxes, deposits and other outstanding dues for the said flat. Again, let us decode this. First of all, there is an unlawful element here. The law says that they can only give you possession after occupation certificate is received. In other words, after the flat is completely suitable for human habitation. So what is suitable for human habitation? First of all the fixtures have to be done, door has to be in place, balconies have to be safe, electricity, water supply, drainage has to be functional. If they give you before all this happens, it is called fit out possession. Now fit out possession of course is something that happens in the market. It happens in the market. It is illegal, or at least I'll say it is half legal. Fit out possession is given on the pretext that the house is not ready, but you guys want to bring in your interior designer and your carpenter and your, all the mason and all these guys, and they are going to start working on your flat so that by the time they get the OC, your flat will be ready. This is the assumption. This is one set of circumstances when people ask for fit out possession. But you know that there is another set of circumstances where people ask for possession. People ask for possession when they become desperate. They become desperate when the builder is delaying the possession so much that they have run out of money, that they are finding it impossible to bear the rental, and they are impossible to, they find it impossible to bear the EMI burden. So EMI burden plus rental burden is falling on them. They are not able to carry on. Then they say, please just allow us to come and stay in the flat anyway. We just want to stay, even if it feels like a slum, even if there is no electricity, no water, we will manage. Please allow us to stay because we are in financial desperation. Can it happen with Runwal My City Phase 1 Part 1? I'm not sure of this, but it may have already happened. It may have already happened because their original date of possession was in 2019, and the date they are giving now is December 2022, end of this year. So there has already been a 3-year delay. 3 years is the period of time which within reasonable period you should be able to go from 0 to 100. You should be able to put up a whole new project from scratch within 3 years. That is considered a fairly reasonable period. Now 3 years they have delayed the possession. I don't know how many people have become desperate. If you become desperate, if you start asking them, begging them for fit out possession, then what they will tell you is, give us the entire amount, regardless of the stage of completion. Give us the entire sale price of the flat. Interest, so if there was any late fee that they had imposed on you, interest, taxes, deposits. What kind of deposits? Maintenance, for example, 18 months of maintenance for the society, clubhouse charges, etc. Blah blah blah. Give us all the money. You know where they would be unfair to do this? Suppose they have not done internal plastering, or suppose they have not done door work, flooring work, etc. They will still probably charge you for it. They will ask for whatever they feel like asking, and you will give it to them. And if you don't, your allotment will be cancelled and the money that you have given them will be forfeited. This is what they are saying. Now, being a reasonable human being, you will say, boss, there is such a thing as rule of law. कायदे को कानून भी तो कोई चीज है, fairness भी तो कोई चीज है. There is such a thing as being fair. They are a big company, they are a well-known company, Runwal. They won't be unfair to us. Really? Really? Let me tell you that they have taken away from people who have paid 80% of the amount. There was a chap who booked a Jodi flat. Some 85 lakhs or something was the total consideration. He had already paid 70 lakhs, and then he said, give me inspection of my flats before possession. I want to inspect my flats. Otherwise, I'm not going to pay you anything more. Remaining money, 15 lakhs, I'm not going to pay you until you give me inspection. Is that reasonable? I think that's reasonable. You know what they did? They sent him a forfeiture letter. They said, your 70 lakhs is gone, forfeited, go to hell. Do what you want. This is what they did. You can't look at it in terms of fairness. They say, this is our rule. Forget about the laws of India. Forget about fairness. Forget about your equality. You are not equal. You are nowhere near equal to us. What we say is the law. What we say is the rule. This is what they say. Now, when they say that you will pay them everything, 100% of the flat consideration, you may have to pay them for the work that has not happened, doors and windows and maybe flooring. You will just have to pay it to them, and then they may give you entry. Again, we may grant you such permission, subject to your payment of entire sale price, interest, taxes, etc. They are not saying it as a matter of right. They are not giving you a right there. You have no rights. They may grant you fit out possession if you do all this. Okay, now let us come to point number 8. Please listen to this very carefully. It has been agreed that timely payment of all amounts demanded by us from time to time towards progress of the project is of prime essence. Let me add to this. Giving you the flat in a timely manner is definitely not of prime essence, because if it were of prime essence, then you guys would have had your possession in 2019. I'm talking specifically about My City, Runwal My City Phase 1 Part 1, from where I have got this agreement clause. If that were of prime essence, then you would have had the possession already. Very clearly, they have not been able to give possession to everybody. Have they given it to somebody? I don't know. Everybody clearly not, because they are very clearly saying that it is December 2022, date of possession. You can give me feedback on what is your status, what is the status of your flat, and whether they have intimated you about further possible delays. But what they are saying here is, forget about the possession of the flat, when we give it, when we don't give it. Timely payment of all amounts demanded by us, not requested, demanded, from time to time towards progress of the project is of prime essence. That is the heart of the contract. Please be clear again. This is not an allotment letter for your flat. This is not a promise. This letter does not promise you anything. This letter only puts more terms and conditions upon you, and you are made to accept them, sign and accept them. Then they are saying, you have confirmed to us, okay, that an intimation forwarded by us, that is Runwal, that a particular stage of construction is commenced, will be sufficient, shall be, shall is more forceful than will, shall be sufficient proof to that effect. So, if they send you an intimation letter saying that 24th slab is in progress, it means 24th slab is in progress. You cannot question it, you cannot say give us further proof, give us architect certificate. No. If we said something is happening, we have sent you an intimation letter, that is itself the proof. Are you clear? However, it is agreed. Now look at the other side of it and see how they word it. However, it is agreed by you that failure to receive notice from us requiring such payment shall not be a plea or an excuse for non-payment of any amount on their respective due dates. Let me explain this. What they are saying is, suppose they say they have sent you intimation for starting of 24th floor slab. Suppose you for some reason they did not receive it. It is possible that they did not send it to you. It is possible that they sent it to the wrong email address or the wrong postal address. You did not receive it genuinely, and it may be verifiable. However, that date will come and go. If you are supposed to pay them in January, on 1st Jan 2022, and that was the date for payment, and you failed because you did not receive the intimation, then they will send you a notice for penalty, and suppose that doesn't reach you, they will send you another notice for more penalty, more interest, and so on. They may even cancel your flat. They may cancel the allotment and send you a forfeiture letter. When you come to realize it, you may say, boss, I didn't receive this email. That is the reason this whole thing happened. And you know what they're going to say? Sorry, it is your failure to receive the intimation from us. It is not our failure to deliver the intimation to you. The failure of communication is always on you. The consequences of the failure to communicate will be on you entirely. That is what they are saying in this clause. However, it is agreed by you, and you have already agreed to this, okay? You can't dispute it. You have already agreed. Because when you sign on this allotment letter, which you will be forced to do, you are agreeing that if there is no communication, that is a failure on your part. Failure to receive notice from us requiring such payment shall not be a plea. You cannot make an excuse. You cannot make a plea. You cannot say, please listen, this is the reason I have not paid. No, nothing. They will not listen to anything. It is also agreed that in case of failure to make payment as demanded of any check getting bounced during the payment of any installments, we shall inter alia be entitled to forthwith cancel the reservation of the flat. So suppose the check bounces. Why does it bounce? Oh, well, you were wrong. You made a mistake of a few hundred rupees and there was insufficient balance. The check bounced. Their check bounced, no explanations, they can cancel your reservation. Now what it means, if they cancel your reservation, does it mean they give you back the money? No. We we shall be inter alia entitled to forthwith cancel the reservation of the flat, and all amounts paid by you, all amounts, all, shall stand forfeited. Is this reasonable? Suppose you have paid 85%, suppose you have paid 95%, and then there is one bounce check. Is it reasonable that they should forfeit it? No. Is it lawful? No. But they are saying they can do it. That is what they are saying here. And you will be signing. Okay. It is also agreed that in case of failure to make payment as demanded by any check getting bounced during the payment of any installments, we shall inter alia be entitled to forthwith cancel the reservation of the flat, and all amounts paid by you shall stand forfeited. Then they are saying one more thing. We shall be additionally entitled to pursue any legal remedy against you if required. Means we will take away all your money. We may still sue you. We may still go to court against you. And we are entitled. That's what this allotment letter is saying. Point number 8. Read it. Please go to RERA. Most of you, anybody who has already booked in Runwal Phase 1 Part 1, you would have signed this allotment letter. I am sure you would have signed this allotment letter and you won't know it. You probably haven't read it. And if you read it, you say, I don't have to take it seriously. This is all words. They don't mean anything. No, they mean it. They take away people's money, lots of money, pots of money, lakhs of rupees. They have taken it away. They will write a letter saying your amount is forfeited, now go to hell. This is what they do. Is it gundagiri? Yes, it's gundagiri. Is it dadagiri? Yes, it's dadagiri. Is it unlawful? Yes, it is unlawful. They are taking money from you at knife point, at gun point. They are holding you hostage. They are saying, they are threatening you with grave loss, grave financial loss. Is it unlawful? Damn right it's unlawful. Are you submitting to it? Damn right you are submitting to it. That is the weakness of the flat buyer. That is the overwhelming dominance of the builder. This is Runwal's allotment letter. I only reached till point 8. I'll explain the rest of it to you. But these are the points that you are forced to agree. Where is your dignity? What are your rights? Forget rights, forget dignity, you're nothing. Think about that for a bit. I am Krish, the Urban Naxal. Jai Hind, Jai Maharashtra, Jai Jawan, Jai Kisan.